appreciate your calling this hearing. Ms. Clarke, I want to ask you about the potential enhancement of bail-in jurisdiction. In light of the department's prior experience administering the pre-clearance regime, what's your opinion about the necessity of amending Section 3C to permit courts to bail in jurisdictions for violations of the Voting Rights Act, in addition to cases where there have been violations of the 14th and 15th Amendments?
Thank you for that question, Congressman. So the bail-in and bail-out provisions of the Voting Rights Act are important features of the statute. They allow a way for jurisdictions that may have long and recent histories of voting discrimination to be brought into the pre-clearance process. Likewise, bailout allows for jurisdictions that have a clean bill of health for 10 years to be removed or exempt from the pre-clearance process. And we know that there's scores of jurisdictions that avail themselves of the opportunity to bail out when we had the pre-clearance process in place. Overall, I think the bail-in and bail-out features of pre-clearance make clear that Congress designed a very carefully tailored statute that allows for expansion, allows for restriction based on the records of those jurisdictions. I encourage Congress to look at those provisions and see if there are ways to perhaps make it even easier for jurisdictions to bail out, or alternatively, easier to bring jurisdictions in, particularly those that engage in present day discrimination when it comes to voting rights.
Yes. I've heard now from several of my colleagues on the other side of the aisle about this claim that the state of Pennsylvania somehow violated the US Constitution in the 2020 election and that other states had done that before. My understanding was that 62 different federal and state courts rejected categorically this claim that there was some violation of Article 2 of the Constitution taking place. But as I understand their line of questioning is directed to you, they're basically saying, would you look at somebody's Voting Rights Act claim that, for example, the extension of hours violated the Voting Rights Act? Is there any reason you wouldn't look at that to determine whether there was an invidious intent or an invidious effect under the Voting Rights Act?
Thank you. Again, protecting the right to vote is an important priority for the Justice Department. It's something that Attorney General Garland has made clear repeatedly. And as we look at the picture across the country, our review is a narrow one. It is focused solely on understanding whether jurisdictions are changing the rules, adopting new restrictions in ways that harm protected minority groups who deserve the right to be able to access the ballot free from discrimination. This is not a partisan exercise. It is a very limited review and limited jurisdictional role that the Justice Department has.
Yeah, and no courts have ever found that there was either a constitutional or a statutory problem with the kinds of changes that they're talking about from the 2020 election, much less that there was a violation of the Voting Rights Act. But it's interesting that they began by proclaiming their fealty to federalism, but they're attacking voting practices in particular states, as in Pennsylvania. But I want to thank you for your service, and I want to thank you for very carefully threading the needle to help us come up with a statute that will stand the test of time and vindicate our overwhelming constitutional interest in making sure everybody gets the right to vote. I yield back.